as Johnny just told you, I've been doing this since 1990. And I really seriously need a brain transplant or adjustment. For having done it for that long, it's all the mic off. I turned the mic off? Oh, he did. So it's not picking up. Is this working? Can you guys hear me? Yeah. Okay. I'll keep going. See what happens.
I think I can.
Is it picking up on the for the recording, or do you know?
Keep talking.
Keep talking. Okay.
Yeah, I think it's coming.
Okay, we're good. Okay. Kind of like the legislature, things never go quite the way you think they're going to go. So Bart and I are going to tag team this, and I'm going to take about the first 30 minutes or so and tell you what's happening in the legislature and try to answer your questions, and then Bart's going to give you a case law update. And when I'm done, I'm taking off because I've got to get back to a legislative luncheon meeting or a strategy session. We're going to talk about some stuff. So the difference with the conference this year is it's being held before the legislature is over. So we're not really absolutely sure what the legislature has done or what they are going to do to us with regard to some of these bills. So we're pretty sure, I think, of most of the bills where they're going to go, but we'll go over some of those. I think you have a handout that I gave to you. This is a list of bills that I am following as the chair for the Utah American Planning Association chapter. And I do this every year. And then I also send out emailed updates on this list and keep adding to the list as things pop up in the legislature. And just kind of try to keep everybody in the loop and up to speed of what's happening. And as I say, we're not done with the session. And we're not going to talk about all of these bills, because all of these bills are probably not relevant to you. But if you have a question about any of them that I don't talk about, by all means, at the end there, go ahead and chime in and ask about it. First one I want to talk to you about is this House Bill 83. Not really a lot to say about that one. It's an odd bill. I'm really not sure what's prompting it, and I guess I need to find out. But what the bill does, it's very, very specific to something. So when you have a two-party multifamily condo that somebody wants to subdivide and turn into a couple of single-family condos, the process to do that, this bill will allow counties and cities, it allows everyone, but only in first-class counties now. Originally the bill applied statewide, but now it applies only to Salt Lake County. Allows them to set up a fund that can help to reimburse the costs of doing that. So doing surveys, preparing plats, paying the fees. I'm not really sure what the impetus behind that is, but it seems to be some kind of a way to assist in the costs of turning basically duplexes or two-family unit condos into single-family. I don't know. Really kind of odd. As I say, originally it was proposed to apply to all counties, all areas of the state, and it was made mandatory originally that you had to set up a fund for that. But as people talked to the sponsor and said, what are you trying to do? It got narrowed down to Salt Lake County, and it's a may rather than a shall. Is anybody here from Salt Lake County? Salt Lake County part of this? No? Okay. I shouldn't have talked about it. Who cares what happens in Salt Lake County? We're going to eventually, is anybody here from Summit County? Oh, good. We can talk about it. We do have a bill or two that relate to some of the things that have gone on in Summit County, and we'll kind of talk about that in a minute. This House Bill 104. It's a bill that's not going anywhere, but many of you saw it, and I did hear from many of you with regard to this. So what this would have done over the years, school districts, and all school facilities, and then even charter schools were given certain exemptions from the state code regarding land use. So they're made exempt for many of the provisions in your zoning and development ordinances. The rationale behind that was schools are public facilities, they don't have a lot of money anyway. They shouldn't be made to go through all of the rigmarole that we darn planners always come up with and the communities wanted to do. So they have over a period of time been made exempt from a lot of those things. This bill would have removed all of those exemptions. And as you can imagine, it got people in the education business a little bit worked up. The bill eventually got characterized in the press as being aimed primarily at charter schools. that was not the case. It wasn't aimed just at charter schools, it was aimed at all schools. But the bill's not going anywhere, and the real purpose of the bill was one of our friendly communities who just felt like they could not get the cooperation and attention of their local school district, so they did this bill, and it got attention. It got the attention of the school district. Now, whether that's going to make a difference or not, I don't know. But really, this bill was not really intended to be passed. It was aimed to be a message to try and catch somebody's attention. And it appears to have accomplished that. I'll leave them nameless. It's probably better to do that. And not to impugn the reputation of some entities and folks. House Bill 108, a mobile home park task force. So, if any of you have dealt with mobile home parks before, you know that they're a sticky wicket. They're a tough issue to deal with, particularly if someone is proposing to close it and move all of those people out, or all of those people are going to have to move out, and all of the issues that go around that. So, this bill would actually establish a task force at the legislative or at the state level, and the issue of mobile home parks will be looked at for the next year. What happens when you close it? What can be done about it? How can the people who have to rent or have mobile home parks there and have to relocate, what are the issues they have to face, and how can they be assisted? Are there any kinds of restrictions that can be put on this process? What can be done to encourage new mobile home parks? And how should they be done? I mean, the list of things that this task force is going to look at is pretty long. And it's pretty broad, covering a whole variety of issues with regard to mobile home parks. And I think that bill is going to pass, because it's passed the House, it's over in the Senate. So that's going to occur. The League of Cities and Towns and the Association of Counties, I believe, are each going to have a member on the task force. So it's going to be one of those things I'm sure we'll hear some more things about as they proceed with their work over the next year or so. House Bill 125, which is Electrical Transmission Facilities Siting Study Act. So the siting and approval of electrical transmission lines has been a pretty big issue over the last few years. And in particular, in a couple of counties, Tooele County, Box Elder County have had big issues with that over recent years, but I know it's an issue in a number of other counties as well, maybe not to the same degree or the same kinds of concerns that happened in Tooele and Box Elder, but it continues to be a big issue. And how to deal with it and the processes. This particular bill would actually put some new requirements in place that before a new electrical transmission facility or line can even begin the process of acquiring right-of-way, they would have to go through a process of a state-level study commission, or a study to be done, and to look at issues with regard to the siting of that facility. Now, I don't know, I didn't read the bill in a lot of detail, and maybe some of you will know who may be a little closer to this. I don't know that it actually gives them the authority to do anything. I think it just, Mike, it just requires you to take a look at it, right?
It theoretically allows the PSC to intervene, is really what it would probably do. It's solve the problem, it allows the PSC to be one of those, it basically drags it into the community pipes.
Yeah, okay, yeah, makes it part of it. Yeah, okay. And it's going to continue to be a big issue, as we all know, particularly as the emphasis at the national and on many levels seems to be increasing on renewable sources of energy. And those renewable sources are often in remote locations, and they need to be tied into the grid. As new power stations are built and tying them into the grid, there's going to be more and more issues.
The original intent of the first one, D44, was to try and do some of the same things, but it got morphed so many times that it no longer heads that way.
Yep, that's right. So, keep an eye on that one. I think that's probably, right now, it's not removing very fast, but I think probably will pass, but we'll see. Things get kind of goofy here in the last week. Let me jump down to House Bill 220. So this particular bill has kind of gone through some interesting iterations. What the bill does is this is actually something that has been an issue of concern with regard to the vacating of plats and recording of new plats over vacated plats or in place of vacated plats, and what role they have. There were some issues that were hanging out there, and it's been talked about for the last couple of years. This bill finally addresses that. Ostensibly, what the bill does, the main thing it does is that when you amend a plat or vacate a plat, first of all, it requires that when a plat like that comes forward, land use authority, which is generally your planning commission, it could be somebody else, but it's generally the planning commission. The land use authority has to notify all entities that provide services to the property that the plat that's being amended, so that they are at least aware of what's going on and that they can be notified of that. And then it clarifies that when the plat is ultimately then approved and is recorded, that it supersedes any previous plat. I guess there were some issues hanging out there that wasn't clear in some cases as to just what it did and which plat still had force and what provisions. So this is just making clear that a newly recorded vacation of a plat or amendment of a plat, that new plat supersedes everything else that went prior to it with regard to that property. It also requires now that not only the owners that are affected by the plat amendment have to sign, but also the land use authority has to sign. So those are really some technical issues, but just things you should be aware of and need to take care of. The bill also does another interesting thing, and I guess this has occurred. I thought everybody had a planning commission because they're required to have a planning commission, or you've at least designated them as a local land use, your locally designated land use authority, but I guess not everybody has. So this bill says that if you have a designated land use authority, then the governing body is by default land use authority. Just something to, I guess, to clarify what's happening. Okay, let's see. Oh, and there's another interesting provision here as well that's kind of stuck in there. This whole concept of vested rights. Did you talk about vested rights and all that? Not today. You have in the past. But the idea of vested rights, which is that an applicant submits an application to you under your rules that are in place at the time they submit a complete application. They're now vested to go forward under the rules you had in place at the time that they submitted that complete application. This bill also puts some language in the state code with regard to that, so that it's a little bit more clear. That was all. A lot of that was just based on case law, but now it's
was that still 220?
Yeah, that's still in 220, right? So as far as technically doing things with regard to our local land use processes, 220 is the bill that probably does the most, and it's probably the one that you have the most interest in. Let's see. I talked about House Bill 258, which was business licensing amendments. It mainly applied to cities at that time. I don't remember if it really applied to counties, but it would have exempted a variety of types of home businesses from even being required to get business licenses. And that was based on an issue that somebody had in the city of Lehi. You know, this is the interesting thing about the legislative stuff. So much of what we see in the legislature is based on something that happened in somebody's city or county, you know, in their local jurisdiction. And they don't like it, and so somebody decides to run a bill on it. And that's one of the reasons why the League put together the Land Use Task Force, where we meet with developers and realtors and folks on the development side and talk through some of these issues. And usually, then most of them don't even find their way into legislation because we try to deal with them in other ways, particularly if it's something that only applies to one place. But not always. That doesn't always happen. We have legislators and others who, of course, can file any bill they like that aren't tied into this process or don't care about the process, and they run their own things, and that's what this business licensing bill was all about. It's pretty well dead. It's not going anywhere. So, House Bill 370, canal safety amendments. So you're all aware, I'm sure, over the past few years, we've had some issues with breaches of canals, failures of canals, damaging of property and structures because of the failure of canals, and in at least one case where we even had a couple of deaths that occurred from the failure of the canal and the inundation of the property. Everybody recognizes that it's a problem. The solution of the canal companies, and canal companies are interesting beasts, probably a lot of you know that. They're more often than not, they're a group of farmers that got together years and years and years ago and just decided to run a canal, and they all agreed to do it. And they really, they formed a company, and it's ostensibly a company, but it really, it doesn't have much in the way of assets. It doesn't really run much like a company. And for them to say to them, okay, you got to spend money to fix that canal and make sure that it's safe, ain't going to happen. It just isn't going to happen. But it's an issue. It's obviously an issue from what we've seen happening around. It's one of those things that nobody really knows what to do about, because it's clear what the problems are, but what to do about it is not so clear. One of the discussions was to require them to have insurance. Well, again, they generally don't have any money, or very much money. In addition to requiring keep canals fixed or safe. The solution that some of the canal companies came up with was just don't allow development around canals. Well, you can imagine how the property owners felt about that, where the canals were running through. And this is an interesting thing about canals, from a legal standpoint that I've heard. A lot of people think that canals, by virtue of their being there and crossing property, they have like a right to be there now because they've been there for so long. They don't. They kind of come under a different, and I'd have to turn to some of you legal people like Brandon and me in the back, but they are apparently there by virtue of permission of the property owner. And if the property owner were to say to the canal company, get off my property, they probably have to get off. And so they really don't have a right to be there. In many cases, not all cases, but in many cases. So it's a real interesting issue. In many places, before subdivision and development is approved, they will require the developer to go to the canal company and say, ask them what if they'll sign up on the plat or sign up on the development. And oftentimes the canal company will simply say, if you pipe our canal, or do something to fix it, improve it, make it better. Well, I don't know that we really have authority to do that, nor is it clear that they have the ability to require that. Probably clear they can't require that. So it's a big can of worms. It really is a big can of worms. What this bill does at this point, first thing is, we don't know for sure where all the canals are. There aren't really there's not a very good database out there of canals and what condition they're in. And so this bill establishes the ability to basically map all of the existing canals in the state and to sort of put together an assessment of their condition, but not really, because that raised another issue. So let's say you map all of the canals and then you classify them as being safe or not safe. Well, then what? Now you're developing a piece of land that's next to a canal that's deemed to be not safe. Who's responsible for that? To do something about that? It's not very clear. So these are a lot of things that are going to have to be worked through, and it's going to take time. But at this point, this bill provides some money and allows for the mapping of canals, and then it also establishes the ability through some state programs to help with making improvements to those canals. It's very limited, but there is at least some ability to do some fixing and shoring up with some of those canals. So I'm sure we're going to hear from more about this in the future. Question in the back.
Does that change any of the requirements for the canal bill requirements the year previous of having insurance on the canal or having them develop?
It didn't change any of those provisions. So whatever was already there, it doesn't take any of that away. It doesn't change it. So that's whatever was there is there. This is just something new. This is kind of like the first steps in trying to address what we may wind up doing eventually about canals and how they relate to adjacent land uses. House Bill 383, restrictions on sand and gravel extraction. This particular bill, again, it was related, I think, to a particular instance. I can't remember where it was now. Was it in Tooele? Yeah, that's right, it was. Tooele, you're a troublemaker. And in this particular case, it would have restricted the opening and the operation of a new gravel and sand operation within 2,000 feet of residences, public buildings, or churches. And again, it's related to the impact of gravel and sand mining operations. This bill, it's not going anywhere. I don't think it's going to pass. But that continues to be a concern out there, and I know in many communities it is, so we're likely to see that issue come back. House Bill 388, Amendment to Transportation Funding. This is a bill that really, at the beginning of the session, had no legs whatsoever, and now it's got a lot of legs. What this bill does is it allows for counties to hold a vote and decide to increase their sales tax for transit. It's not limited to any county, so any county can do this. And you know, if you're going to do transit, I mean, obviously you're probably going to have some kind of transit system in place to really make use of this. But the counties are in the driver's seat with this. They can actually enter into agreements with, if they decide they're going to do this, they put it on the ballot, they pass it, they've got this pool of money coming in. The county's in control of the money, not the transit agency. And the county can sign an agreement and put together some kind of an agreement with the transit agency for what kinds of services they can provide and what they want them to do. So this will apply to all counties, as I say again. And as I say, when the session started, this thing had no legs. It does now, and it's likely going to pass. Anybody want to guess why? Why would this suddenly get legs like that? Now, all has to do with one big issue that's become like not big issue this year. Air quality. It's related to air quality, and so it's kind of become a big deal, like to show that we're really doing something about air quality by enhancing transit. House Bill 422, Initiative and Referendum Impact Disclosure. So, we've talked in the past about the whole issue of referenda, particularly as it relates to land uses. And we've had some examples in the last couple of years of some land use referenda that have overturned developments and development approvals and some of the issues that causes. We had a big one in Layton, and there's another bill I'll talk about in a minute that really kind of relates to that. But this one relates in particular to all referenda, but in particular to one that happened recently in, I'm going to say the wrong community, Saratoga Springs? Yeah, Saratoga Springs, okay. Where in essence you had years ago where a developer came in and proposed a development in the community, signed a development agreement with the community, went ahead and developed a golf course, a number of single-family homes that had an area for higher density development that was included, but they never rezoned for it back at the time they initially approved the development. Well, now the developer was ready to go forward on that higher density part of his development, and you can imagine what happened with the neighbors. They did not like it. Well, the first step in order to be able to do that, even though they already had a development agreement signed with the community, was they needed to get it into the proper zone, so the city council rezoned the property. The neighbors got enough signatures, put it on the ballot, and eventually passed it in this last November's election. The developer is now saying to the community, you have breached our development agreement. We are going to sue you. Now, you know, that's something that, don't you think that's something that the residents should have known before they voted on it? And some of them probably did, but you know, there's a whole interesting issue that surrounds when you have something like this, which is essentially a political campaign. The city or the county, the governmental entity, really, they can spend no public money to basically get out their side of the story. Because it's seen as campaigning on political issue. So what this bill would do is it would allow for, or even require a community for any referendum to prepare what's called a fiscal and legal impact analysis. So they would prepare saying, this is what the financial impact if this referendum passes, and the legal impact might be if this referendum passes. And then that can be distributed out, and basically, you know, an awareness campaign can take place to get that information out to the community. That's what this bill will do. And so that seems to have pretty good legs, and it's probably going to pass. Let's hurry, because I'm running out of time. SB 51, that particular bill with regard to transit agencies, primarily UTA in this case. The previous legislation with regard to UTA allowed UTA to become partners with developers on a limited number of transit-oriented developments. The idea here being, as UTA acquired facilities, as they built primarily their rail facilities, they in some cases acquired more property than they needed, in some cases a lot more property. But then they make good places for transit-oriented development. UTA is able to enter into a partnership with developers, but if the state law limited to only 5 locations, because there was some uneasiness about having UTA being involved as a developer. This particular bill, there was a lot of debate about it. It originally was going to take off all the restrictions with regard to that. Again, the legislators weren't sure about it. Now, it increases the number from 5 to 10. So UTA can now be involved in up to 10 transit-oriented developments around on. The next bill I've got under Senate Bill 82 is one related to billboards, and there's another one a little bit further on, Senate Bill 223. These are basically the 2 dueling sides in the billboard debate. Let me just tell you this, read them, they'll alarm you. You'll want to write your congressman about it and everything else after you read the bill, but just be aware these bills are going nowhere. It's again an issue where we've got the one side puts out their bill, the other side puts out their bill. Legislative leadership is saying, we're tired of this fight. Until you guys can get together, we're not passing anything. That's what happened last year, so it's going to happen again this year. So these 2 bills may get a committee hearing. They were supposed to, but tomorrow's the last day of scheduled committee hearing. But that's as far as they're going to go. So don't worry too much about billboards this year. Don't know what may happen in future years. Potentially something may occur, but not this year. Senate Bill 169, Public Meetings Materials Requirements. The bill originally specified that so your planning commission meetings, even your governing body meetings, as you had electronic material that came forward into it, you needed to post all of your information electronically and include the electronic material that you got from others that they submitted. This was kind of onerous to the recording authorities and those that dealt with this. This bill has been modified substantially. At this point, all the bill requires is that if somebody comes to your public meeting and submits to you electronic information, so let's say they show up and have a PowerPoint, and they want to show the PowerPoint at the meeting, and you let them, they plug your laptop in, it's up there on the screen. They have to give you a copy of their PowerPoint stuff or their electronic stuff. That's all the bill requires. Okay? They just have to give you a copy of the electronic material, and you have to keep it with your stuff. That's part of what was presented to you. That's all the bill does. SB 184, Local Government Inspection Amendments. So this is where we get to pick on Summit County. Apparently, Summit County angered the development community because apparently what was happening was that there are a number of large developments going on in Summit County. They're collecting substantial amount of fees, and it takes a long time to get inspections done. And so the developers have said to the county, why don't you hire more inspectors, because this is just crazy that we're having to wait this long. And Summit County has basically said, it's up to us. So the bill originally would have required that any of the money generated in permit fees has to stay within that department. It can't be used anywhere else in the budget. Well, that wasn't any good for the rest of us. So this has been batted around back and forth a few times, and where the bill sits now for counties and for cities, but not for towns, it says that you have to provide inspections in a reasonable time frame, and for cities and counties, not for towns, although for cities and counties, that reasonable time frame is 3 business days. You have to perform the inspections within 3 business days, and if you can't perform them in 3 business days, then you have to hire a private independent inspector to go out and do those inspections for you so they get done in a timely manner. Okay? That's what the bill requires.
The jurisdiction would have to hire.
Yes, not the developer or not the builder. The jurisdiction has to hire and provide that service through their process. Now,
Is it
some
a
people have
pass?
said, well, gee, how long might it take us to hire? Yeah, it may take you a few days to hire somebody and get them out there. The bill doesn't address that. So it just requires you to do it sometime. So
The challenge it creates for some of us that are very rural is
yes,
we schedule appointments for one day a week.
Yes.
For instance, for Greenwood, because
and that's been brought up.
that's the only way that financially it makes that it can work.
Yep.
We don't do those, we hire that out. That's the only way the contract can work. And so this will force some relooking of that and actually probably force the fees to go up.
Yeah, it would if you have to do it, but this bill isn't done yet,
Yeah.
and that's been brought up, that issue.
For a lot of counties, I think that's actually the case, they only do it 1 day a week in certain communities.
Yeah. Yeah. So just be aware that that one's hanging out there, and we'll see where that winds up, where it ends up. Let's see, what else we need to talk about real quick. SB 211, the water rights amendments, I mean, there's been a big ongoing fight over the conversion of water rights from agricultural or other kinds of uses to the municipal uses, and that fight continues to go on, and this kind of resurrected some old stuff and continues to do that. Senate Bill 228, this is the other referendum bill that I told you about. So one of the concerns, and this came up particularly in Layton, where they had a referendum over a development in a particular part of the community, and the residents all around that development were really concerned. They had enough people in that area of town to collect the signatures they needed and to get it on the ballot, and then enough of the other people in the rest of the town didn't care enough about the issue to probably even vote on it at all. But the residents that lived around it cared about it, and they voted it down. They voted down the development approval by the community. And so the issue was, you're voting on a referendum community-wide, and it should be something having to do with a community-wide impact, but yet you can have something like this occur where it gets put on the ballot and is defeated by a small group of residents in a particular area. This particular bill would require that when you're collecting signatures for a referendum, particularly in like a city or a county, you have to get the required percentage of signatures in 50% of your voting precincts in your community. Right? So the idea is to kind of spread out that distribution, that it isn't all just coming from one area. So that's what that bill would do, and I think that's got a pretty good shot of passing. Now, I say that, I was just listening as I came in on Doug Wright's show, a discussion about the count my vote thing, but they got into a discussion about referendum, and the discussion was, Utah has, with all of the rules they passed about getting a referendum out to a public vote, it's already really hard in this state to do it. We shouldn't be adding any more rules or restrictions on doing referendums. Well, these two bills do that. And so it may get caught up in the bigger issue of just the appropriateness of referendum. Last one I want to talk about, Senate Bill 249, Transportation Right-of-Way Safety Amendments. This is the latest attempt to try and restore at least some ability to do eminent domain for trails. Every time you've all heard, many of you heard the story, this was removed years ago due to an issue in Mapleton City with a private developer, a private landowner in the city down there, and it has been virtually impossible to get it back in the subsequent years. And it keeps getting whittled down, whittled down. This current version of the bill now would allow eminent domain for trails that are adjacent to state roads that are being used for a transportation purpose primarily, not just for recreation. And there's a whole bunch of other things in there. I mean, it's very, very limited. And it's really being targeted at a trail in Weaver County, in the Ogden area, where they want to finish the trail and they can't because they've got some holdout property owners. And all of these requirements in here would fit that situation. I'm not sure how many other situations it would fit. Probably not a lot. But the issue is trying to get the camel's nose back into the tent and maybe then eventually be able to broaden out that ability to do eminent domain for trails in the future. Okay. I've gone way too long. I'm not giving Barb enough time. Quick, any questions? On the trails bill, it's a good first step. It's a good first step. It's a very small first step. I don't know. I think so, but it's tough to know on this one because this one keeps getting caught up in the really conservative ethic of, not doing anything to harm property rights. Okay, Bart?
prepared my slideshow and keynote to discover that we couldn't run it, so I quickly converted it to PowerPoint, which means that all my notes are not showing up here. So I'm going to try to do what I can on the fly as we go through the slides talking about these cases. The other caveat is that I chose cases that I think lenders knew they were interesting to me, but I chose them with planners in mind, so I hope that they prove useful to you. If you look in the handout, I've given you a case law update handout. It has the cases and the key points from those cases here. I think it's going to... Excuse me. I think this is going to be posted on the website. If it is, I've linked all these. They're hyperlinked to the actual cases. So if you want to take a look at the cases, go to the website, find this, and link right through to the actual cases and actually read the language itself. And there's a lot more there than what we're going to go over today, obviously. So let's go ahead and begin. Of course, the big takings case from the United States Supreme Court last year was Coots versus St. John's River Water Management District. This is actually a picture of St. John's River in Florida. It's actually quite a large waterway. It runs through most of the state. Sometimes it's very, very broad and run pretty large boats down it. It's also home to alligators, and sometimes, as you can see, it gets a little overgrowth. And so there's a real concern about wetlands along the river. And so the management district requires developers to dedicate some property or do something to mitigate any wetlands they're going to build on. So what happened here is Mr. Koontz had some property and he wanted to develop it. So he said, you know, I'm just going to develop on a couple acres of my property and I'll give you a conservation easement over 3/4 of the remainder of my property. And the management district said, no, we don't like that deal. Here's what we'll let you do. You can build on a smaller part of your property, you can give us an easement over the rest of the property, or you can pay us some money to mitigate wetlands elsewhere within our district. And Mr. Koontz said, thanks, but no thanks, and he sued them. Went through the courts, it's kind of a storied case, eventually gets to the Florida Supreme Court, and the Florida Supreme Court says, there was no taking here by making that demand on Mr. Koontz for two reasons. One was because the district denied his application because he wouldn't agree to the conditions. It didn't approve his application with the conditions. So because of that, no taking ever occurred, according to the Florida Supreme Court. We never took any property from him. We just said, if you want to do this, these are the conditions you have to meet. He didn't meet them, and so we never took his property, no taking. The other reason the Florida Supreme Court found no taking was because there was a demand for money to mitigate wetlands elsewhere. They said, look, a taking involves real property. All you're asking him to do is to pay for mitigation elsewhere. That's called a monetary exaction. Because it's monetary, it doesn't involve real property, it's not a taking. So it eventually made its way to the United States Supreme Court. The United States Supreme Court, unlike what you may think based on the news, the United States Supreme Court usually issues unanimous or majority decisions. Very rarely you get the 5-4 split that you hear all the time about. That's usually on really hot-button issues. But this case gave us a 5-4 split. The majority, well, first of all of them agreed unanimously that it didn't matter when you're talking about takings whether you approve with conditions or you deny because the applicant won't agree to your conditions. It doesn't matter. When you're talking about exactions, whether you deny or you approve, it's a constitutional question both ways. And the reason is because, granted, if you exact from them when you grant them the permit, yes, that is a taking. You're taking something from them. But if you deny because they won't agree to the conditions, then you're violating what is called the unconstitutional conditions doctrine. And this is what exactions are all about. It's all about the unconstitutional conditions doctrine, which basically said you can't interfere with someone's constitutional right. It's tantamount to violating the constitutional right. So what you're doing when you're saying you agree to these conditions or you don't get your permit is you're basically interfering with their constitutional right. And because of that, then you're violating the Fifth Amendment in this case. So they all agree that that happens, either whether it's a condition precedent or a condition subsequent. Where they disagree is this question of monetary exaction. The majority say, yes, you're talking about money, but you're talking about money related to a distinct property interest, an identifiable property interest, and because of that, it's a taking. It's a taking question. The dissent disagreed. They say, look, counties, cities, they all have the power to tax. A tax, we all know, is not a taking. So if they have the power to tax and they have the power to request a monetary exaction, it's the same thing. Ergo, you don't have a taking when you have a monetary exaction. The majority disagreed, so on a 5-4 vote, monetary exactions, as settled by the United States Supreme Court, are takings. And so you should be aware of that when you're requesting any sort of mitigation fee or other kind of fee on a development approval. One thing that the dissent did say that I think is going to get some traction is they said, look, when you, whatever the story is for monetary exactions, when you're making a demand for an exaction, the demand has to be unequivocal. Because another thing the dissent said here is, look, what the district did is it gave Mr. Kuntz some options. It said, you can give us the easement, or you can pay us some money and have us mitigate elsewhere. They said this was not a concrete demand. And they said, what you need before you can even undergo the takings analysis is to have a concrete demand for the applicant. And this wasn't concrete enough. And I think that that's probably going to gain some traction. You're probably going to see some development along those lines in the future. Was there a demand? Wasn't there a demand? It really wasn't reached in this case. All right, so for exactions, no difference between granting a permit with conditions and denying an application for refusal to agree to conditions, and the Nolan-Dolan, which is the exaction analysis, applies even to monetary exactions, as long as there's that direct link between the exaction and the specific piece of property. So another case, Utah Court of Appeals last year, Johnson versus Weaver County. This one involved a school, and it was Green Valley was the name of the private school, and they were seeking a design review application for a residential facility in an ag zone that would specialize in students with depression and developmental issues. The planning commission said, well, it's a school, so it's a permitted use in the ag zone, we're going to approve it. Citizens didn't like it. They basically said, all this really is it's a group home, a residential treatment center under another name. We don't like it. It's not allowed in the zone. They appealed to the Board of Adjustment. The Board of Adjustment affirmed the county and said, no, it's a school, it meets the definition. The citizens took it to the district court, which also ruled for the county and the school, and then it eventually made its way to the Court of Appeals. And the Court of Appeals said basically a facility that offers a similar education and curriculum to a public school is considered a school, even if it's residential, and even if it offers additional programs. They say school is an umbrella term. They can't identify, or at least they hadn't identified in the ordinance, every particular type of school allowed. And since schools were permitted use, just because it was residential and just because it provided these services, then it was allowed in that zone. So you can see perhaps some area of litigation in the future when you have what have been called in the past group homes styled as schools. You're going to run into this conflict more and more frequently, and it might be something that you would be wise to visit in your own ordinances in counties. Olsen versus Park City, picture of some homes here in Park City. This dispute involved timing. So in this dispute, let me see if I can grab my notes here. In this dispute, Park City adopted an ordinance that approved the subdivision, and it created a single lot from 3 other lots. So it wasn't in the case, but I imagine someone building a larger home where there used to be 3 smaller homes. This usually raises the ire of neighbors. The ordinance was passed on February 25th, but it said it would take effect upon publication, which didn't occur until March 3rd. Some landowners filed suit to challenge the ordinance, but they challenged it on March 31st. So if you count the 30 days to challenge from the passage of the ordinance on February 25th, they were too late. If you count it for when it was published on March 3rd, they were fine. So the city moved to dismiss and said, hey, it wasn't timely filed. The district court granted the motion to dismiss and held that it wasn't filed within 30 days from the enactment, which it said was when it was passed. Court of Appeals disagreed. The Court of Appeals said, no, an ordinance isn't enacted until the last event necessary to make it legally binding is performed. Here, by the ordinance's own terms and by the statute, it doesn't become binding until it's published. It wasn't published until the 3rd, so therefore it was timely. So here, also, it quoted from Perez, which is a personnel case, but they basically said the Supreme Court said in Perez that you have to have a clear trigger date and a way to issue the decision to the public before you can start counting your 30 days. So make sure those two things have happened if someone is challenging one of your ordinances on timeliness grounds. Another interesting case was Hatch versus Kane County Board of Adustment, which came out last year. This is an interesting case. Mr. Hatch had a subdivision, well, he claims he had a subdivision approved in the 1970s. And at the time, he said that he didn't have to comply with the subdivision ordinance that was in place in the 1970s because under the ordinances of that time, if all of his lots were over 10 acres, he didn't have to apply. He had an old letter from the county attorney at the time basically stating as much. So, but the county didn't have any record of the subdivision. There was nothing recorded, no plat recorded about the subdivision. And if you looked at the plat that he gave them, some of the lots were under 10 acres. So it didn't really make a lot of sense. But the critical error of Mr. Hatch in this case was that he was applying for a building permit. He had taken a bunch of those lot lines and converted them into a 40-acre lot that he wanted approved for a building permit. And he had done that recently, not back in the 1970s, and he admitted as much. Well, that's the problem. They said, well, you know, there's a lot of questions about whether this subdivision was approved back in the 1970s, and you can imagine records in Kane County back in the 1970s from the subdivision ordinance. I mean, it's a little touch and go. But they said, look, let's assume, and this was one of the points as well, is there's such a thing as a non-conforming use? Is there such a thing as a non-conforming lot? And the Court of Appeals said, we're not going to answer that question. There's a lot of case law that seems to indicate it's not decided in Utah. We're not going to address it because we can address it on this other ground. So we're going to assume for the purposes of the argument that there is such a thing as a non-conforming lot, even perhaps a non-conforming subdivision. But you can't go change the plots in the subdivision, in the non-conforming subdivision, without conforming to the subdivision ordinance that's then in effect. So you can have a non-conforming subdivision, let's assume. You can have non-conforming lots, but if you're going to change those around, you need to get the county's approval under the subdivision ordinance then in effect. So he didn't do that. So they said no. There were also some issues here about how the decision of the appeal authority was handled. The county attorney wrote the decision for the appeal authority. He gave it to opposing counsel to take a look at. No changes were made, so he submitted it to the appeal authority who signed off on it. Court of Appeals said that's fine, unless there's some indication that there was something inappropriate going on. It's done all the time. That's fine. You don't see a problem with it. Also, this was after the switch over to making transcripts by tape recording, and the transcript, the official transcript of the record that was transferred to the court, was full of all these statements saying that what was being said was inaudible. You'd be reading along, and suddenly a sentence would just end, and it would say inaudible, because the court reporter were listening to the recording, couldn't tell what people were saying. And the court said, that's fine, unless you can identify some sort of prejudice, we're not going to open it up to an evidentiary hearing. That's what Mr. Hatch wanted. He wanted to have a hearing all over again. The court said, no, we haven't identified anything that's missing from the transcript. The prejudice is used, so that's fine. Let me kind of speed up here so I get you guys to lunch. The Powder Run versus Black Diamond case, this is up in Deer Valley. The two homeowners associations squaring off and involving Park City as well. This is another 30-day limit case, but it's a question about quiet title claims. I encourage you to go look at it. I'm not going to get too far into it here because of the time issue, but basically, it's basically saying the quiet title claim that was brought in this case, what happened is Black Diamond dedicated to the city a part of its easement that ran over Powder Run's property for a public road. The city said, fine, we accept it as a dedicated road by ordinance. Black Diamond laid some utilities in it, paved it over, and opened it up to the public use. It wasn't until 9 years later that Powder Run brings a quiet title action. And the city says, 30 days. You have 30 days. We passed an ordinance accepting the road. You have 30 days to bring it. You're out of luck. And Powder Run said, we're bringing a quiet title action. No statute of limitations. The court said, no, what you're really doing is you're trying to overturn the ordinance. It's 30 days. You're stuck with the 30 days. So let's move on here to Carter versus Lehi City. This was back in 2012, but I'm going to raise it here because it was such a game changer for petitions, for referenda, and initiatives. And it involves a case that was that came out last year called Kretschy. Okay. So Carter versus Lehi basically rewrote the standard for when a petition can be accepted for the ballot. There used to be all these different kinds of tests for determining whether something was legislative or executive or adjudicative. And under the Constitution, the power to bring a petition or a referendum is limited to legislative action. So the question always was, and this applies to other parts of land use as well, because we're always asking the question on appeal, well, was this legislative, which is under a lesser standard of review, and was this administrative, which is a higher standard for these substantial evidence tests. And they basically said, throw out all the old cases, throw out all the old tests, that just led to confusion. What the test that we're going to operate on is legislative if it involves a law of general applicability and requires weighing broad competing considerations. So what does that mean? Well, they said, all right, there's these two hallmarks. Laws of general applicability can apply to everyone engaging in the same type of conduct that the law addresses. And number two, it's weighing broad competing policy considerations if it doesn't involve the specific facts of an individual case. In other words, if it's creating a new law instead of just implementing or enforcing the law. So that's the standard that we have. They went through and they offered some examples of when this would apply. And they said one of the questions that we still have is about site-specific zoning. We're leaving that undecided until we get a case that allows us to address it. We gave a couple examples where it would be clear. One is where it's a recharacterization of a zone, and another is where the entity that passed the ordinance only has legislative powers. They said that's per se legislative. We'll say that's legislative. But as far as an entity, for example, that has executive and legislative powers doing a site-specific rezone, we're not answering that. Well, this year they did answer it in Kretschy versus Saratoga Springs, the case that Wolf was just mentioning. In this case, the citizens brought, as Wolf was saying, a petition to put a question on the ballot. There was an approval of an increased density zone. The court said site-specific zoning like this is legislative and is therefore subject to initiative and referendum, and placed it on the ballot. So I don't know if that has been voted on yet or not, but basically the court said there's a state law that says the opposite. They said no, it's a constitutional right. It's not granted by the legislature. The power of the people to bring petitions for initiative and referendum is not devolved from the state legislature. It devolves from the state constitution. The legislature cannot constrain it. All they can do is set manner parameters. That's all. So they can't substantively constrain the right. So they said what you really look at is the Constitution. They said this met the standard because, for two reasons. One, they said that it doesn't affect, although it doesn't affect other pieces of property, it's generally applicable because it's going to affect the property owner now and future property owners. So even though it involves only the present property owners, because it's going to stick with the property, then it's generally applicable. So you have sort of this concept of lateral general applicability and longitudinal general applicability when you're talking about that element of whether an act is legislative. And they said it is also implicates the weighing of broad competing policy considerations, because they said, look, it's not like a variance, it's not like a conditional use permit. If you look at a variance, you have standards set out for you in the statute and in the ordinance that you are applying to a particular act. You're not creating new law. Same thing for conditional uses. Therefore, we find that it's legislative, and there you have it. That's my review in time for lunch. Thank you.